So friends, using the shadow docket with its complete absence of legal reasoning, the Supreme Court is doing untold damage to the American people and to our institutions of government, or perhaps more accurately, courtesy of the shadow docket, the Supreme Court is allowing Donald Trump and his administration to do untold damage to the American people and to our institutions of government. In today's Justice Matters video, I talk with constitutional scholar and constitutional law professor Kim Wehle about this and other legal issues like the Supreme Court's erosion of the Fourth Amendment prohibition against unreasonable searches and seizures as it pertains to our Hispanic and Latino brothers and sisters. We also talk about the dangers of the Supreme Court's presidential immunity ruling, among other topics. I hope you enjoy today's interview with law professor Kim Wehle. Let's get started as people are joining. So I'm here with my friend Kim Wehle. Kim is a constitutional scholar. She is a tenured law professor at the University of Baltimore Law School. Have you been teaching there 17 years now, or did I make that number up?
I think that sounds about right. Yikes. Yeah.
She has also been a legal analyst on a number of news networks. Are you presently still doing that with ABC News?
Yes, I'm still with ABC.
And Kim, as I always say, is the author of a whole bunch of not how-to books, but why-to books, how to read the Constitution and why, what you need to know about voting rights and why. And really the book that is of moment is the Pardon Power book that she wrote not too long ago, Pardon Power, How the Pardon System Works and Why, though I'm wondering if it is working at this moment. Certainly, not as intended, but especially the Pardon Power book is so timely right now because of what we'll discuss in a few minutes, which is, the combination of the Supreme Court granting Donald Trump absolute presidential immunity and, declaring that the pardon power is a core constitutional power. Those two things together feel like they could spell the end of our republic. I know that sounds hyperbolic, but I don't believe it is. And I believe Justice Sotomayor in her dissent suggested that. So we're going to leave that till the end. But first of all, thank you for jumping on with us, Kim.
Always such a pleasure to chat with you, Glenn. And I appreciate you and I appreciate your whole team that is committed to this work, which is so critical and vital, not just for us, but for our kids and our grandkids. The millions who can't vote, right? They can't vote for their freedoms. They can't vote for their liberties. They can't vote to sustain democracy. They rely on the adults in their lives to do it. And the only way we can do that in an informed way is to have these kinds of conversations, to educate ourselves on how the system works and to share what we know and enlarge our circle. So it's I'm always up to chatting with you, Justice Warrior Glenn.
Well, and the reason I texted you early this morning, Kim, is because I read your most recent piece about what's going on the shadow docket. And I know you have an uncanny ability to break it down into understandable, digestible, layman-friendly terms. So what I wanted, and let me encourage everybody now, and I will do it again later, to please follow and subscribe to Kim's Substack. It is at Kim Wehle, Wehle. She is now calling it the Little Law School, which I think is a great branding of it. And here's what I want to do. I want to just read the opening salvo of your brand new piece, and then we'll launch into a discussion of the shadow docket. You say, for decades, it's been no secret that Donald Trump lacks respect for the law. Since he took office in January, the rule of law has taken too many body blows to count. It's also well known that the justices in the 6-3 majority on the Supreme Court, half of whom were handpicked, are extremely loyal to Trump. Scholars will debate the implications of their pro-Trump rulings for years to come. That's to be expected. It's how the majority is handing Trump keys to the kingdom, that is, through the shadow docket, that is especially troubling this round. So, can you tell our viewers, first of all, what the hell is the shadow docket and why does it seem to be having a moment right now, in your opinion?
The shadow docket's just a name that another law professor assigned to a procedural mechanism to short circuit normal Supreme Court review, and to get emergency cases resolved immediately. That's basically the idea. So historically, think about people that are on death row, right? They have a night or two to get their claim that their death sentence was unlawful before court after court. The governor says no. If it's in a state that the governor can relieve the death penalty and give life in prison, and their last resort's the Supreme Court. And there might not be time in the 24 hours to go through the whole process of getting a case fully briefed before the court. So the court will issue a shadow docket emergency ruling and say, listen, we're just going to stay the current death sentence, the lower court's decision that can go forward until we can really think about the merits, the heart and soul of whether this person is properly on death row. And so what's the full process? The full process for getting something before the Supreme Court is you've got to file a brief, a motion, a long piece of paper asking the court to take your case. It's called a writ of certiorari. 4 justices have to agree to that. And that has other briefs like opposition. Should you even take it? When they take it, then they'll schedule it for full briefing. You get each side gets really long briefs, gets a reply brief, and then you have amicus briefs. It could be hundreds and hundreds and hundreds of pages. Law professors, interested parties weigh in. The idea is the court gets all kinds of points of view on the topic because they know they're making law for the ages. It's not just for that case. It really, when the Supreme Court interprets the Constitution, it's like an amendment to the Constitution. Glenn, if you and I do it, it takes supermajorities in the state legislatures and in the federal Congress to get an amendment. 5 justices who are there for life, appointed, not elected, get to do it. Then they'll hold oral argument. Then they sit on it, they debate it, they'll issue rulings that can go tens, sometimes over 100 pages. The shadow docket cuts through all of that and says, okay, this is an emergency. We're going to reverse the lower court now because otherwise something really bad will happen to the party wanting it reversed. So remember, we talked about, okay, what bad could happen? Someone could be executed. Their life is over. What is Donald Trump doing since January 2nd? He's making the argument the irreparable harm, the injury that's so emergency is I basically can't do whatever I want right now. So the reason that this is such an abuse, Glenn, is because things like, does 8 people who are being sent to South Sudan, they're not from South Sudan, they didn't get due process. In South Sudan, there's a political crisis. They could be tortured and murdered in prison there. Their lawyers say, listen, we need to see whether they should be sent to South Sudan. The lower court said, yeah, we agree. Don't send them. Supreme Court on an emergency says we're going to let Donald Trump do what he wants to do and send them to South Sudan without due process. Things like DOJ. DOJ is a made-up agency. Agencies are created by Congress. Can DOJ, who we don't know who these people even are. Are they federal employees? What are their names? What's the purpose besides efficiency? Can they get, Glenn, Americans' private, protected information with the Social Security Administration? Your most personal stuff that you give to the government. Can DOJ just have that and rove through it because they want it for efficiency's sake? Lower court said, no, we got to figure out why the heck you want it. If you're complying with all the laws that protect individual personal private information, the Supreme Court said, emergency, Trump wants it now for efficiency. DOJ, whoever you are, gets all that private information on an emergency basis. So the Supreme Court is sidestepping the deliberate, thoughtful process of getting the briefs, hearing the oral argument, and explaining its ruling, giving us one paragraph, reversing the lower courts, giving Trump what he wants on this fictitious notion that it's an emergency when presidents don't get to do what they want right away. I mean, Glenn, if that was the standard, we wouldn't even have any lawsuits against the government because they would always get to do whatever they wanted because their argument would be, I would have to wait till litigation is over. We'd never be able to sue the federal government. That's the standard that the Supreme Court appears to be adopting for one president only, Donald Trump, because they certainly weren't this amenable to Joe Biden's emergency petitions.
And this is why I love talking to Kim Wehle, because I think you bring it into such sharp focus when you talk about how, a common occurrence when it comes to the shadow docket, having to decide things quickly, are like in the death penalty arena when somebody is headed to, the death chamber, which is what they call where they execute inmates. And this thing needs to be decided right now, right? So I guess I would say the shadow docket can be used for good. It can be used to protect the rights of people, who are in this emergency situation. In layman's terms, maybe somebody on death row wins a reprieve because the Supreme Court puts a temporary stop to the execution while they more fully flesh out the legal issues involved. Wouldn't it be nice if the Supreme Court granted a reprieve to democracy every once in a while in the way Donald Trump seems to be killing so many aspects of American democracy? But now let me ask you, what are the dangers of the shadow docket, and what, if any, benefits are there to the shadow docket? And I think you've already brought one to our attention, putting a temporary hold on executions to make sure they're not wrongful executions.
Yeah, so it's kind of like a temporary restraining order. If anyone knows anything about those, a TRO, say you've got somebody who's stalking you, or there's a domestic abuser, and you need to get a judge to basically say, stop what you're doing until we can figure out whose rights are being violated, if anyone's. All that a shadow docket ruling does is it puts a hold on the lower court's decision. So the hold in the death penalty thing would be like, we're not going to execute you yet. You might still get executed, but we're just going to wait till it plays out. The danger with what the Supreme Court is doing is by the time, this stay on behalf of Donald Trump, we're going to put a stay on the lower court's order, stopping him from destroying the government, basically. And by the time you get to the actual case, the damage is already done. Like he's winning the war under the pretense that this is just a temporary decision. It's not a temporary decision. I mean, one of the rulings, Glenn, had to do with the Department of Education, right? Can the Secretary of Education just fire tens of thousands of personnel within the Department of Education, potentially in violation of law, including people that implement things like the laws protecting disabled children or the laws protecting low-income children, the people who actually write the checks from the federal government to local schools. The lower court said, listen, the status quo is what's in place until the case gets resolved. Supreme Court said, no. It's not the status quo. It's what Donald Trump wants that is in place until the case gets resolved. Well, by the time they get around to maybe ruling that the lower court was right and that the president can't just ignore acts of Congress and throw away agencies, the agency's gone, Glenn. The people they're lost their jobs. These kids suffered from whatever benefits they didn't get. Like the schools didn't get the money they were supposed to get because there was no one there to write the checks. So they had to close, or they had to close down programs. I mean, the Supreme Court is letting Donald Trump do all the damage and saying, oh, we'll get to it later, when we all know, using our logical minds, listen, the wrecking ball already smashed the building. So, I need the injunction now to stop the government from smashing the building. Because if you let them smash the building now, I won't get it back later. And that's essentially the court saying, no, we're going to let him smash it now. And then maybe later we'll require that he put the pieces back together. I mean, so that's one of the problems. The other problem, Glenn, is that these are major issues of constitutional importance. The Due Process Clause of the Fifth Amendment, Congress's power to appropriate money, to decide how it's spent, Congress's power to create agencies, Congress's power to dissolve agencies, USAID, Congress's power, we'll see what happens with the tariffs, Congress's power to decide how the president gets to hire and fire certain people, like Lisa Cook of the Federal Reserve Board. When you're going to change precedent, you're going to alter the Constitution. It's birthright citizenship. That case was on the emergency docket. It's black and white in the 14th Amendment. Historically, when the Supreme Court's going to make major changes to constitutional law or reverse decades of precedent, one case, Humphrey's Executor, 90-year-old precedent, the court basically did away with it in 3 of these emergency petitions. Lawyers, judges, the public needs to know why. We need an explanation. We need to know, why did you change the law? Why did you ignore the Constitution? Why is this old law that we've been living under for 90 years now all of a sudden gone? And there's some ambiguity as to whether these shadow docket rulings count as precedent. Lower court judges have treated them as not precedent because there's no explanation. But at least in one instance, the Supreme Court chided a lower federal court judge and not following these one paragraph rulings with no explanation. So these lower judges are lost in the dark. And some of them, I know one of them spoke to your former network, NBC, and said, listen, we feel like the Supreme Court doesn't have our backs. They're reversing us willy-nilly, and we don't know what we did wrong.
It turns the whole idea of irreparable harm on its head. Because as you point out, there would be no irreparable harm if the status quo, like, congressionally funded government agencies and the people employed by those agencies continued to do the hard work of the American people in accordance with the law and with Congress's funding of those agencies, and taking the time to actually fully litigate those issues. It doesn't seem like there is irreparable harm in keeping the government functioning the way the Constitution envisions it should function. And as you point out, and when you point it out, it infuriates me anew, because there is no irreparable harm if Donald Trump's government is made to wait until these issues can be fully litigated by the Supreme Court. So let me ask you this: why? Why, in your opinion, we can't look in? I think about my 30 years as a trial court prosecutor. I can't tell you how many times I heard the judge instruct juries, ladies and gentlemen, there's no way to look into the workings of the human mind, right? We don't have that ability. That's why you get to infer motive and intent from conduct and statements. If you had to give your best estimate as to why they're doing this, what would your take be on that?
Well, the other piece to the irreparable injury, Glenn, of course, is that they're ignoring the irreparable injury to the government employees who lost their jobs. They're ignoring the irreparable injury to the students who now don't have a decent education or don't have the Department of Education there protecting their rights. So there is irreparable harm by what they're doing, which underscores the importance of your question, which is, why are they doing it? I'm writing, you mentioned I'm a tenured law professor. I'm writing actually a scholarly piece on this to try to make sense of it and be fair to these justices. And what I think it is it goes back to Trump versus United States, the case from June 2024, 1 year, that fundamentally rewrote our constitutional order, where it gave presidents immunity from committing crimes. They can commit all the crimes they want, so long as they use their constitutional Article 2 presidential power. If they use, their personal power, you can still prosecute them. But if they're using the power, that's the scary stuff, the one that can really ruin people's lives, they're unaccountable. And so if you imagine, I think like the lesser it subsumes the greater subsumes the lesser. That is, if presidents commit crimes with no oversight from Congress or judges, then it seems to me they can take civil actions. They can restructure the government. They can hire and fire people. They can do less troublesome, less potentially menacing and damaging things under this umbrella of sovereign power. I mean, I really think these justices have this view of presidents like they're kings. And they really think that because there's only one president, that's not a panel, that they have unilateral authority to use that power as they see fit. And I think they believe, appears to be, they believe in a consolidation of governmental power behind one person. Now, of course, the cynic in me says, well, what's good for the goose should be good for the gander. That is, they should have had this view of presidential power when Biden was president, and they didn't. So, I hate to say it, Glenn, because I have deep respect for the Supreme Court. I've not appeared before the Supreme Court. I've written briefs in the Supreme Court. I appeared before the D.C. Circuit in our oral arguments, but I really think there's an ideological bias here. It's a political institution, and I say in my column, I think they're committing judicial malpractice, and it's a sobering thought, but it's deeply, deeply troubling because they cannot be fired at the ballot box. Even Donald Trump, in theory, can be fired at the ballot box, or the Republican Party come the next presidential election cycle, but Supreme Court justices can't.
Yeah. And before we move on to the Supreme Court amending the Fourth Amendment, I know that sounds smart alecky, but that to me is what they did. Let me just finish up by saying, and you already touched on it, when you have trial court judges and appeals court judges, the federal circuit courts of appeal, who, first of all, the trial court conducts hearings, sometimes full-blown trials, and reaches very thoughtful, supportable opinions and decisions and rulings, sometimes, as you say, authoring, 70, 80, 100 page tomes setting out why they are ruling the way they are, including lots of precedent that seems directly supportive of their rulings and their conclusions. The appeals court, like the Ninth Circuit Court of Appeals out in California, then affirms that. And the Supreme Court on the shadow docket says, guess what, folks? You're all wrong. Not going to tell you how, not going to tell you why, not going to give you any guidance to make it right moving forward as you continue to litigate this very case, but you're all wrong. That's beyond disrespectful. That, I maintain, is corrosive to the operation of the federal judiciary. And, it feels like the Supreme Court, in what seems to be counterintuitive, is sort of destroying the legitimacy of the very branch of government that the justices sit atop. And I have no explanation for that.
I think they're drunk with their own power. They're untouchable. And I've said, we've had these conversations before. If there's no tickets for speeding, people will speed, right? Once you get the speeding ticket in the mail, you'll slow down on that street because that there's a machine there that can tag you. There's no tickets for speeding in the Supreme Court, and there's no tickets for speeding in the White House. And that's where we are. But I want to underscore another point you made. The shadow docket actually has a test, a 4-part test. The Supreme Court is supposed to not just take any old case. They not only are supposed to consider who's actually being harmed if they interject their views, which, as we talked about, it's not Donald Trump really being harmed. It's the people that Donald Trump is targeting that are clearly being harmed. But also, they're supposed to only step in if clearly the lower courts got the law wrong. We're talking about the plain language of Section 3 of the 14th Amendment guaranteeing birthright citizenship. We're talking about 90-year-old precedents. We're talking about the appropriations clause in the U.S. Constitution. We're talking about the Article 1 lawmaking authority of the United States Congress. I mean, this isn't hard. I mean, this is not any gray area where maybe the lower court got it wrong. They clearly didn't get it wrong because they're applying the plain language of the Constitution. So this is these justices literally throwing out before our very eyes the plain language of the Constitution in certain instances. And we're supposed to consider them conservative? They're supposed to be textualists? Oh, they're originalists? They care so much about the plain language. They're not even adhering to it. And that's why, Glenn, I think, you're all the work you do, and I hope people do sign up for my little law school Substack. I think it's so important for people to understand what's really going on in the court, because these words, conservative justices, are thrown around, but they're not conservative, they're radical. It's actually the progressive or more liberal justices that want to keep the status quo. They're like, whoa, 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 whoa. Like, we're not supposed to be doing it this way. We're supposed to be applying the law, and we're supposed to be following the procedure and the 4-part test and looking at irreparable harm and adhering to precedent. Like, what are you guys doing? They're actually the conservative justices, but we talk about them the wrong way.
Yeah, and I have to make a smart alecky point because I'm a Jersey guy and it's part of my DNA. And when I read, and this is going to transition now to the Fourth Amendment case, where I think they amended the Fourth Amendment, or at least said racial profiling is good to go if you're a Hispanic, you're Latino. Um, but when I saw in Brett Kavanaugh's separate concurrence, there was no majority opinion. At one point, he said, "My goodness, if we ruled otherwise, we might have to overrule precedent." Perish the thought. And I wanted to say, Brett, have you met Roe v. Wade? Come on now, sport. We're not buying that nonsense. So let's talk about a piece, not the piece I wrote for Substack, but I titled it The Fourth Amendment Amended, which of course the Supreme Court doesn't have the legal authority to amend the Constitution. Um, and yet, when you look at the Fourth Amendment, I am a con law geek. I am not an expert the way you are, but the Fourth Amendment is my favorite amendment, right? The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. They amended it to add a clause unless you look a certain way, you speak a certain way, and you happen to be in the vicinity of day laborers. Then guess what? You're shit out of luck because you don't have the Fourth Amendment protections in the same force as others do. So, what is your view on what I believe to be a horrific mangling of our Fourth Amendment protections?
I mean, I agree with you. And again, I mean, it was nice that Justice Kavanaugh gave us some explanation, but his explanation was this whole, well, Trump wants to fix immigration, so we have a lot of immigrants in LA. I mean, it's this idea that, well, the president wants to do it, so that's a reason to dispense with the Constitution. I mean, and I know you, having with all your vast prosecutorial experience, you know better than I do probably. You've got to have reasonable suspicion that someone violated the law. And in the dissenting opinion, I think it's Justice Sotomayor, she says, speaking Spanish, being of a certain nationality or a race, and being at a car wash where you work, there's no reasonable suspicion of the commission of a crime. It's pure racial profiling. And, Justice Kavanaugh acknowledged that this could be illegal, that the practice could be illegal. There was no dispute. The government wasn't trying to pretend they weren't doing this. They flat out admitted that this is what they do. And he admitted that there's even violence potentially. But he said, well, that's just what happens. Immigration policy sometimes just needs to take this course because we have a lot of immigrants, that some of which are not here in a manner consistent with the law. So rather than actually apply the Fourth Amendment, we'll just stop anybody who has a certain race. I mean, it's really troubling, in particular, Glenn, because as you may recall, the Supreme Court recently held that the consideration of race in college applications, what some people call affirmative action, but it's basically just allowing people to let admissions counselors know that they're Black, for example. That is a violation of the 14th Amendment's Equal Protection Clause. And Chief Justice Roberts, in his majority opinion, says eliminating discrimination means eliminating all of it, except when it comes to the Fourth Amendment and taking people's liberty, right? I mean, when you're talking about affirmative action, you're not talking about taking people's liberty. You're talking about whether they can put that as part of their persona about who they are on their application. The people that are harmed are the white folks that maybe, they are claiming they don't have as equal shot because they can't claim that kind of minority status. I mean, that goes on and on. But the harm here is that people are losing their liberty, even if it's just temporary. It goes back to the Magna Carta, Glenn. I mean, this is why this is why the nobles in 13th century England threatened the monarch and said, we're not going to go along with you being such a bully anymore unless you agree to certain things. One of this is notice and an opportunity to be heard. That, of course, is due process. And of course, the framers of the Constitution didn't want the redcoats, the British Army, just barging into people's houses and searching and seizing pursuant to what was known as a general warrant. The king's curious about what's going on with you. The king can just have access to all your personal information. And that, not only in the case you mentioned, but also in this Doge case with our personal information relating to the Social Security Administration, these Supreme Court justices are saying, sure, they can have all of it because Trump wants it.
And let's face it, it was Judge Breyer, I think, in the California case, if I'm not mistaken.
Judge Charles Breyer, right? You're talking
Yeah,
about?
Judge Charles Breyer. And, at first he had put a preliminary injunction in place. And of course, that didn't survive appeal. So then he had a hearing on the merits and found that there was, quote, a mountain of evidence. That's Judge Breyer's term, showing that ICE agents, federal agents, are sort of violating the Fourth Amendment writ large. And all he did was put an injunction in place that in substance said, stop violating the Fourth Amendment. And the Supreme Court vacated that. They threw it out in a very real sense, saying, no, continue violating the Fourth Amendment using racial profiling. And here we are. So let me
and also, Glenn, one more other point is I'm sure you picked up the Task Force 51, which was the combination of the California National Guard that had been co-opted by Trump as well as the Marines, right? They were trained not to do this, and it came down from the Defense Department. No, you can do it anyway. So the point is that even the training, as I'm sure is consistent with every law enforcement apparatus in the entire country, is reasonable suspicion. This is really, really a flagrant disregard of not just the Fourth Amendment, controlling Supreme Court precedent, but decades of practice. So what is the message being sent to other law enforcement, to the FBI new recruits that now don't get 20 weeks of training, they get 60 days of training, that don't need a college education. The ICE recruits that are getting big bonuses for joining ICE. I mean, what is the message being sent to these people, not just in terms of violating the racial profiling, but taking other steps that, the Fourth Amendment applies to your person as well. Seizure of your body is also protected against under the Fourth Amendment, not just, your personal belongings. And I think this is a green light for more violence from the government against potentially innocent people without the Constitution intervening, because the Supreme Court thinks it's okay for Donald Trump to suspend the Constitution for now.
And Donald Trump is having a day because he is somebody who told a gathering of police chiefs from around the country, for example, when you put a suspect in the squad car, don't be so nice and gentle. You don't have to protect their head from the door jam when you're putting them in the car inferentially. Just go ahead and bang their head into the door jam. And this is the same guy who during campaign rallies, when some protester was, making his or her voice heard, exercising their First Amendment rights, Donald Trump would say things like, knock the hell out of them and I'll pay your legal fees. It feels like Donald Trump's sort of his appetite for violence is having a moment and is in part being sanctioned by the Supreme Court. And that leaves us in a horribly dangerous place. Let's finish up with this, though we could do hours on this topic. I will never get over and never stop talking about the presidential immunity decision. You mentioned the name of that case, the caption, and I think that caption speaks volumes.
Yeah.
Trump versus the United States of America, right? And that is really the age we're living in. It is a wannabe dictator, an aspiring autocrat against the United States of America, against we the people in so many ways. And, I wonder if you agree with Yale Law professor and constitutional scholar Akil Reed Amar, who wrote, I think, famously now in his Atlantic piece, in that case, the presidential immunity case, the Supreme Court ruled that the Constitution is unconstitutional. And, I don't know how they did it. I guess maybe the why is, again, they want to consolidate power in the chief executive. I don't know. But what is your view of that? And do you think there's any hope? I already know the answer to this question, that maybe that will be revisited, in the near term, not 40, 50, 60 years later, like we had to wait for, Dred Scott to be corrected, Plessy versus Ferguson to be corrected, Korematsu to be corrected. Do we have any hope that that may be remedied in the years to come?
Well, yeah, we have discussed this before, Glenn, as you know, and I've like read this opinion many times, painstakingly, line by line, trying to understand it, and the dissents. I think there's America before Trump versus U.S. and there's America after Trump versus U.S. I don't think it's possible to to overstate, I should say, the significance of that ruling, because it's all about incentives and disincentives. Donald Trump made really clear in his private life and during his first presidency and during the campaign. He's convicted on 34 felony counts. The other two or three indictments didn't make it to trial, thanks to the federal courts and the Supreme Court. But he came into office making clear he doesn't care what the law says. He doesn't care, right? The Supreme Court took away the consequences for not caring about the criminal laws. It just said, okay, well, you can continue to not care. And by the way, you cannot even be indicted for it after you leave office. Do whatever damage you want. Commit as many crimes as you want. Sky's the limit. Steal money from the taxpayers. Assassinate your political enemies. I mean, read the dissenting justices. They're talking about this. You are off scot-free. No one can touch you. You are untouchable. So is it a big surprise, Glenn, that he's acting like he's untouchable? Is it a big surprise that he's blowing through legal guardrail after legal guardrail after legal guardrail? The question is no longer, and we're lawyers and we do this for a living, and I encourage everyone, again, to continue to educate themselves. So the question is, what's the law said? I think is important. But the more critical question is, if we are in a post-rule of law presidency, which we are, what do we do? What do we do about the fact that the law no longer operates to constrain bad behavior the way it does for me and you and everyone in our community? We stop at stop signs. We stop at red lights. We don't attack our next door neighbors because we know we could get in trouble with the law. That's not the case with the presidency. I mean, so to answer your question, in the old days, I don't know. We're not in a world where we can project in 10 or 20 years what it would be like in a functioning American democracy with a functioning Supreme Court. I don't know we'll ever be in a position where we'll have a Supreme Court that, again, will be able to just look at that case and a normal president and say, maybe we should tweak it. The question really is, will we ever have a free and fair presidential election again? Will we have a functioning two-party system where both parties are committed to democracy and not just to a particular ideological power, struggle and a particular man? And, I know people in the chat are saying, what can be done about it? Step one is education, what we're doing. I wrote a book, How to Read the Constitution and Why. You mentioned it. Step two is courage. Courage. And I talked about this at your Team Justice meeting. People are getting afraid. Things since the assassination of Charlie Kirk are getting even more extreme. We're seeing really terrifying things coming out of Stephen Miller, people being fired for exercising their First Amendment rights to comment on Charlie Kirk's legacy and maybe not. What we're hearing from a lot of people on the right. And so stay in the game to the extent you're comfortable. Speak your truth. And then the third piece is we need numbers, Glenn. Experts have said 3.5% of the population pushing back consistently against a slide into authoritarianism can turn it around. That's historically across the globe. That's 11 to 12 million people every day. Million. It can't just be me and you and a handful people listening. That's great. Everyone needs to say, what can I do today What group in my neighborhood can I form? Have a coffee clutch, or get together, start a book club on democracy, educate some young people, go to the United States Capitol and knock on the door of your representatives, stand out there, meet people, talk to people who don't agree with you, and be open-minded. We need, Glenn, to all come together, party affiliation aside, and hold the line and push back in this moment.
Yeah. And that is, I think, at its core, where we are. I have been saying for a long time, no one person can save us. No politician, no judge, no prosecutor, no special counsel, no Hollywood type. No one person can save us. But we can save us. We, the people, listen, it's always been up to us. It will always be up to us. And that's why when you're scared, when you're anxiety ridden, when you're despondent, when you feel like things are hopeless, you're not helpless. You can do all of those things that Kim just said. And if we all got in the game, and I know the people who gravitate toward, this channel and our discussions, they are in the game. But you know what? Double your efforts, triple your efforts. You can get involved in supporting nonprofit organizations that are in court fighting for our rights every day. They're not our lawyers. We don't retain them. We don't pay them. But there are dozens and dozens of them. I hesitate to begin naming them because there are so many. Help them. I mean, if you can donate, donate. If you can support them with a door knocking campaign or whatever, you can write voter postcards. You can obviously call and write and text and email your elected officials, not just in Washington, but everybody from the member of your town council and your school board, your mayor, your governor, up through your United States senator. And something that Senator Sheldon Whitehouse said not too long ago when I was interviewing him, you can reach out to your friends and colleagues and family members and coworkers in red states and urge them to contact their elected officials. If you happen to live in a blue state, reach out to the folks in red states and get them to do it. And the other thing, this is not my idea, it's Senator Whitehouse's, post every day how Trump and his policies are hurting you and your friends and your neighbors and your family members and your coworkers, and just flood the zone with accurate information about how much damage is being done. And it doesn't matter if you have 2 followers, 200 followers, or 2 million followers. If we all engage every day in every way we can think, we can get to that 3.5%. I believe we can get to that 3.5%.
Yeah, Colleen L just asked, how do you get to that if the Trump and the GOP doesn't care? I mean, I don't know, but that we've never been at a point where that many Americans have come together to fight for democracy. And I think the magic can happen.
Yeah.
Right. We won't know until we get there. But I do think when we get there, then something will shift. And it's not something we can predict because we've never really been there before. I love the movie Dunkirk, if you've seen that, around the Second World War, about how the Allied forces needed to be rescued from the beaches of Normandy. And, the British got out with their little fishing boats. It gives me chills. And thousands of them in the middle of the night crossed the English Channel and brought these people to safety in the middle of the night. I mean, that's just such a beautiful representation of what can happen when a collective consciousness comes together around freedom and liberty. So I don't have the answer, but I do believe if we all come together around this higher calling, I have no doubt the magic will happen.
And we're going to leave it there because getting to that 3.5%, and Kim says the magic can happen. I agree with her. And I think we all need to be all in for democracy, and we can make it happen. So, Kim, thank you for your passion. Thank you for your voice. Thank you for your teaching. And I don't have to tell you to please keep fighting the good fight, because we are all we have left at this point, and we can make the magic happen. I love that. I'm going to use that as a catchphrase moving forward. So thanks for jumping on with me. We need to do this early and often. And everybody, please, please, please subscribe to Kim Whaley's Substack. You will not be sorry, and you will get this passion. You will get a layman-friendly explanation about what the hell's going on in the Supreme Court. And I believe you'll be inspired as well. So, Kim, thank you, and I'll talk to you soon.
Always great to talk to you, Glenn. Thanks for having me. Bye, everybody.